All rise. Oyez, oyez, oyez. The Fourth Court of Appeals of the Fourth Appellate Judicial District is now open pursuant to law.
Good afternoon. Please be seated. Well, welcome to the Fourth Court of Appeals. The court will now call case number 04-24-509 CB. Matter of Uvalde, Consolidated ISD in Uvalde County versus Texas Tribune et al. Announcements by the appellant first, please.
Charles Furio for Uvalde County, Your Honor.
Thank you. Very good. Are there any splitting of arguments?
Yes, Your Honor, it was split in 10 and 10.
And 10 rebuttal? 5 and 5 each for 10-minute rebuttal. And just miss out. Very good. Thank you. Counselor, you're welcome to come on the podium and proceed.
Thank you, Your Honor. May it please the court, counsel. Again, my name is Charles Frigerio. I, along with Charles A. Frigerio and Hector Sines, represent Uvalde County in this TPI case, as well as all litigation that has evolved out of the Robb Elementary School shooting tragedy. So it includes federal causes of action in federal court and state causes of action, some of which are still pending in state court. This case deals with TPIA, and our exception that we have filed is under 552.108, this law enforcement and prosecutorial information exception. Initially, I'd like to start out by saying that Uvalde County complied with section 552.321, and an attorney general's opinion was issued. So there was a timely attorney general opinion requested. An attorney general opinion was granted, and we allege complied with that attorney general opinion. I believe what is at issue in this case is body-worn camera footage of the deputies from Uvalde County, as well as the internal records, investigative records of the Uvalde County Sheriff's Department. What was given was the basic information page and policies that were requested pursuant to the Information Act. It's important for me to describe to the court the different governmental entities involved in this. I represent Uvalde County. The 38th Judicial District Court, which is the District Attorney Christina Mitchell, represents the state of Texas. When the district attorney acts in a criminal capacity, and as far as criminal prosecution, she is the state of Texas. And that is why the DPIA case with regard to the Texas Department of Public Safety is in the 15th Court of Appeal, as you all know, and that has been argued, and that decision has not been rendered as of this time.
Mr. Frigerio, with regards to the claim of immunity,
yes,
what is the scope that this court should engage in with regards to the exceptions that you have raised? Do we have to analyze whether each exception applies?
Well, the exception that the Uvalde County has raised is Section 108. We believe that applies, and because of the fact of the Holmes versus Morales case, which I believe is the leading case, it may be 1996, but it's still the leading case, and it has continued to been cited by Attorney General Paxton in his Attorney General's opinions.
When you raise an exception, what is your burden of proof, and how did you meet that burden in this case?
In this particular case, Your Honor, we filed in our response to the appellee's summary judgment the 5 grand jury five grand jury subpoenas for our individual Sheriff Nolasco and 2 deputies and 2 constables.
So pause right there for just a second. What is the significance of those subpoenas?
That it's an ongoing criminal investigation.
So just the mere fact that the subpoenas exist is
Yes.
sufficient.
Yes.
How do you prove that the release of public information would interfere with an ongoing investigation?
Okay, that was raised initially in Holmes versus Morales because
But in that case, that was pre-1997, so that second element of the statute didn't exist at that time, I don't believe.
but both of the Attorney General's opinions that I've cited in 2021 and 2024, one out of Wichita County and one out of Wilson County, state and reaffirm in the Attorney General's opinion that by just raising it in the letter, that satisfies the burden. I believe the wording of both of those Attorney General's opinion says that the fact that there was an open criminal investigation or prosecution satisfies the requirement that the release would interfere with the investigation. And what could be more interfering with it than to have, my clients, quite frankly, given subpoenas to appear before a grand jury. And that's what, has been unique to this case and a challenge because at the one hand, we're Uvalde County and the Uvalde County has made a determination that we want to cooperate with the district attorney. Unlike some of the other governmental entities that have taken different paths. But in this particular case, we have always tried to cooperate and have cooperated. And yet at the same time, I had to counsel my clients as to their rights because they had to appear before the grand jury. And that timeline is important because those grand jury subpoenas were issued in April 9th of 2024. Chief Arredondo and Officer Adrian Gonzalez were then indicted under Chief Arredondo had 10 counts and the other officer had 29 counts of child endangerment. Then after those indictments, July 8th of 2024 is when Judge Harrell granted the motion for summary judgment. So it was after all this, and our position is this is not only ongoing, but people are being indicted under this case. It can't be more clear. And because of that, we have shown that it would have interfered with the criminal investigation.
So
to this
when I
day, we
asked-
don't know that whether or not it's even concluded.
So when I asked, how did you meet your burden of proof on the exception, your answer is the 4 documents, the subpoenas is sufficient?
The 5 subpoenas are sufficient that it's an ongoing criminal investigation and that the district attorney is taking testimony in front of the grand jury.
And you don't have to prove that it would interfere? Like that's a conclusion that
No,
we
Your
have
Honor,
to
that's
reach?
exactly what the Attorney General has said in these 2 opinions out of Wichita and Wilson County. But getting back to the ultimate case, the Supreme Court case of Holmes, what was interesting when, as we all remember, District Attorney Holmes, he was famous out of Houston, and there was an issue whether or not closed cases or open cases would be subject to disclosure. And in that case, District Attorney Holmes lost at the trial court level and at the appellate court level. The Supreme Court held, and Dan Morales, the Attorney General, held, his argument was that you didn't prove that it would interfere with the prosecution, and therefore you didn't meet your burden. And the Texas Supreme Court said, no, he met his burden by saying that it's your file, it's the DA's file, their internal notes, and they're always going to be accepted. So that was enough. And the Attorney General Paxton has relied on that case in relying on other instances, I said, out of Wichita County and Wilson County as late as 2024, stating that that is all is necessary. That meets the burden.
I'm gonna step back if I may. On what date was this incident?
Pardon, Your Honor?
On what date did the shooting occur?
It occurred on May 24th of 2022.
And at what date did the media request documents from the county and the school district or the school district?
I believe that's in the record on.
Was it the following day? Was it the following day? What has been produced? I know the list of the documents that were requested. What has been produced? Can you clarify?
On the court's record on volume 9, 127 through 146. So that would be one page of the basic information page, and then policies and procedures of the Uvalde County Sheriff's Department.
Nothing else.
That's to my recollection what has been produced.
has there been any specificity to clear up what has been specifically withheld?
Other than the response, our response to their motion for summary judgment, which would, I believe the ultimate issue in this case is the body worn cameras and the supplemental reports.
And has there been any attempt to redact any of that and turn it over in redacted form, whether it's the body worn cameras or more importantly, the supplemental reports? Has there
No,
been any
we've not.
attempt to do that?
We have just relied on the privilege under 552-108.
You may proceed.
Your Honor, I believe that the case also of Paxton versus Escamilla is important. It's the county attorney brought suit against the attorney general over disclosure of deferred prosecution agreements. The court held that under section 552-108, the exceptions did apply. So we have relied on Holmes. I believe Holmes versus Morales is the seminal case with regard to section 108 and the attorney general's opinions that interpret that. And I believe my time is up and I'll wait for rebuttal. Thank you.
May it please the court? I would like to discuss a couple of exceptions from disclosure other than the law enforcement exception, because I believe that the arguments that my colleague from the county has put forth apply with equal application to the school district. School district is also in a unique position here where they are striving for transparency for their community, but they also need to cooperate with law enforcement and prosecution because those are also matters of importance to their community. I would submit to you all that summary judgment was improper here under additional exceptions in addition to the law enforcement exception. And that there are jurisdictional and fact issues that should be returned to the court to be tried. This is a case dealing with numerous open records requests, volumes of responsive
Ms. Payne,
information.
did you file a plea to the jurisdiction at the lower level?
No, Your Honor, but I don't believe that we're required to file something that is a plea. I think the trial court recognized that we had raised issues of immunity. The order that's under appeal here specifically denied the defendant's assertions of governmental immunity, but we did not file a plea to the jurisdiction.
So when you say motion, the summary judgment was improper, what are you talking about?
I'm getting to that. We believe that there are several exceptions that are applicable here and that the appellees have not carried their burden as to summary judgment. Because this is a statutory waiver of governmental immunity, I mean, it's black letter law that each of those statutory elements must be present at all times or there is no jurisdiction. And that's even if jurisdiction were to be raised for the first time on appeal. So again, this is a case with.
What is the burden they didn't carry? You said the media group didn't carry their burden. How did they fail at their burden?
I think specifically as because we put forth, first of all, I mean, that they have to show that we refuse to provide public information. And our position here is pretty simple. The district received hundreds of open records requests. It timely submitted those requests to the Attorney General's office for a determination. And then whatever we got back from the Attorney General, we produced what they said produced. We withheld what they said you can withhold or you must withhold. And I think that they haven't shown that they're entitled to judgment as a matter of law because we did those things. I will acknowledge that the trial court record could and should have been better developed. But again, I think that because we have the immunity issue that applies to every element of the statute, the fact that the only information that we have held is information that the Attorney General has told us that we can withhold. And those exceptions, I'm sorry, those opinions are due great deference and great weight. And so we think that for that reason, there's a fact issue here. when this similar case was argued in the 15th court, they
So
brought up.
are you saying there's a fact issue as to the refusal to answer the request for public information?
Your Honor, the statute that they've sued us under requires them to demonstrate that we've refused to provide public information. And at the summary judgment posture, they have to show that as a matter of law, and I don't think that they've done that.
Did she provide the public information in every category that they asked for?
That the AG's office told us we should produce.
And you did?
Yes, ma'am. Or yes, Your Honor.
How to respond to, the media coalition when they say, well, you never really identified, for example, evidence that would reflect, what you purport to be raising a fact issue that precludes it. So, their position is like, well, yeah, you can't just say there's a fact issue and you have to prove it.
Sure.
You actually have to proffer evidence.
Right. And I believe that we did so under 108 in regards to the motion for inspection that was received from the district attorney, I believe just maybe a couple of
Well, you
weeks.
came up and said that you were going to address some of the other exceptions. Could you go them by exception by exception?
Sure. First of all, for every exception, there's an attorney general opinion supporting it. And we've asked the court to take judicial notice of those. And we think it would be error for the court not to take judicial notice of those. There's case law saying that even an appellate court can take judicial notice of something like an attorney general opinion. And so those are, that's what we're relying on here. And that goes back to the fact that the district wants to be transparent with its community. So it's only going to do what the AG says it should do. And so for each type of information that's been requested, we released what the AG said released and withheld what they said we had to withhold or what we could withhold.
Okay, so we're going back to the question that Justice Mesa first posed to really kind of identify what the media's burden is and what the government's burden is. You share that, well, as long as we attach an an AG opinion, that's enough as summary judgment evidence that raises a fact issue.
And also as
But you also
jurisdiction.
say-
I'm sorry.
Yeah, well, yeah. But you also say, we didn't technically refuse anything because you really haven't asked anything of us that we needed to that didn't otherwise fall, under a privilege
Mhm.
or an exception to that requires us to, right? So we gave what we were supposed to,
Mhm.
we withheld what we could, so we didn't technically refuse anything. Now I understand where in the record the county evidence is that, hey, we're not refusing this. Where did the school district say that? And that's a tangential question to my original question. If you could just again explain what the media burden is.
Mhm.
Talk to us like we don't know this. right?
Sure. Well,
And what's the initial burden when somebody makes a request, the media makes a request? What's their burden in making the request?
they have to, there's quite a few elements that they have to meet that aren't necessarily applicable here. They have to submit it to the right email
Not the
address,
procedural stuff,
things
but
like
just,
that.
what before the trial court?
Yeah.
What does the trial court review just say, okay, you checked off your burden. Now it shifts to the government. What's the initial burden by the media? Other than making the request, is there a burden like traditional motions for summary judgment?
Yes. So I would acknowledge that the district does have the burden of showing that an exception applies, but in order to obtain summary judgment as the movement, they have to show that they're entitled to judgment as a matter of law. So they have to show that we refuse to provide public information. In response to that, we've provided separate evidence in response to the law enforcement exception, also as regards to the litigation exception, showing when the district, declared catastrophe and when those notices of preservation of evidence were submitted.
You filed a request the day after the shooting.
No, Your Honor.
No?
And our position is
When was the request made?
some of them came in before we would say the litigation exception applies.
Yeah, tell me when y'all made the request, when it was filed. The record reveals, but from your standpoint, when did y'all make the request?
There were several in this case.
The first one.
I don't know that date off the top of my head, but the AG determined that that the litigation exception applied beginning as early as June
You're
5th.
skipping ahead. Okay, I'm talking about when you first made the request
Mhm.
that led to the government asking the AG for an opinion.
Mhm.
That took some time. And
Yes,
this
in part
incident
because,
happened years ago, right? But
Right.
that delay in getting AG opinions through COVID, all that stuff, that's the delay that presents us where we are right now, right?
Mhm.
So you're not really sure or certain about when your first request was made.
I am sure that it was timely, though.
Okay, okay, you're not following me. So let me get back to the original question. So they make a request. Their burden is they've got to delineate what it is that they want,
Mhm.
right? And presumably they believe that what they're requesting does not fall under what is delineated statutorily as confidential or would not otherwise, or they would fall under exception requiring disclosure, right? So let's assume that they did that.
Mhm.
What is then the burden on the government to respond? You're saying, well, we got an AG opinion that we hanging a hat on saying they tell us we don't have to, and we don't technically refuse it. So is that just sort of like a technicality? We haven't really rejected you, but it's like asking, like somebody asked me for a date. I haven't rejected you technically, but I haven't gone on a date with you. On the same thing here, I haven't given you anything, but I haven't technically refused it. Isn't the fact that you haven't made the disclosure in and of itself a refusal?
No, because it requires it to be public information, and the Attorney General has determined that it's not public information.
And there lies the conflict and why
Yes.
we're here.
And
So
those.
the court is asking, and I specifically are asking for you as a party to inform the court what its position is about how the media has fulfilled its burden
Mhm.
and how when it was shifted to the burden on the government,
Mhm.
can you identify again what the burden of the government is generally?
To show that an exception exists, or I'm sorry, not exists, is applicable.
And in your mind, your brief delineates all of that sufficiently. And opposing counsel has raised the issue about the lack of evidence to satisfy your burden. You understand how they're doing that?
Yes, Your Honor.
Okay. Explain to me how you have, in contradiction to their position that you haven't.
Your Honor, I mean, it's clear from the record, in large part, we are relying on the Attorney General opinions, and those are on several exceptions, not all of them, but those are entitled to great weight and due deference, and those are what we're relying on.
Okay.
Without the records themselves, the trial court didn't have any records that you're withholding. This court didn't get any records that you're withholding. How can we engage in a meaningful review if we don't know what we're talking about?
Your Honor, this issue came up when the oral argument in the 15th court, to a certain extent. It is a little confusing, right? When you have summary judgment that then would potentially lead to a bench trial. And so I would assert to you that, hindsight's 2020. Maybe if I could do this over again, we would have done things differently. But we are relying on those Attorney General opinions. We're not trying to deviate from them in any possible way. And so my thought is that those raise a jurisdictional or a fact question. And so then it should be remanded to the trial court, and the trial court should in camera do the inspection of those particular records.
Thank you.
Thank you.
Can I just say, I'll apologize. That is the worst analogy. The dating thing, I don't know why I said that. That just got, it's just never mind. Please proceed, counsel.
May it please the court. Laura Prather here on behalf of the Media Coalition. And I'd like to start with clarifying some of the representations that were made by my friends on the other side and answering some of the court's questions. First of all, with regard to the 15th Court of Appeals case that is pending, that case was not brought against the district attorney. That case was brought against DPS. No records have been asked for from the DA. The DA tried to intervene in that case and was turned down. So the Holmes versus Morales analogy is completely inappropriate, and it's one that is outdated as well because, as your honors noticed, the law has changed. So none of that is at issue. Also procedurally, in that case, the amount of evidence that was submitted to the trial court was significant. There was a thumb drive that represented the 2.8 terabytes of data that DPS holds. There were subsequent hearings about mandatory exemptions. It is a vastly different record than the stark record that appears before this court.
So can you tell us about your burden?
Yes, indeed. Your Honor, the burden for us in this case is to establish that the governmental body has refused to produce public records. We have met that burden. If you look at our summary judgment evidence, exhibits O through V, which are at the clerk's record 872 through clerk's record 920, those show the requests that were made, the 15-day letters we received, and the Attorney General letters that were issued. The lists of the documents that we requested are in our briefing at clerk's record 77 through 80, and it shows all of the different areas of information that have been requested. Then the burden shifts to the governmental body to establish that this narrow exemption applies. And the narrow exemption, as Your Honor pointed out, requires them to establish how disclosure would interfere. And they've done nothing to do that. So let me back up just a little bit, if you don't mind, Your Honor. And I want to talk about the fact that what's being ignored here is the magnitude of the public interest in this case, the purpose of the Texas Public Information Act, and the plain language of the statute. So magnitude of the case. It's been more than 1,000 days since this lone gunman gunned down 19 children and 2 teachers in a classroom while 376 officers stood by for 77 minutes. This has sparked a national debate and conversation about school safety, about gun violence, about law enforcement accountability. And the public has been crying out for answers. And Your Honor, you asked what answers have they been given? Well, this is the answers that they've been given. And it is contained in the summary judgment record, right here. That's it, okay? They've been given an incomplete incident report, redacted policies and procedures about things like canine encounters, and a blank use of force report.
When was the first request made?
Day after. The day after the shooting.
So what is your response to the argument that we stand behind the AG opinions? The AG opinions say, this is what needs to be turned over, this is what doesn't need to be turned over, and we're standing behind that. What is your position?
So there's two ways in which that comes into play, Your Honor. The first is, how much deference does this court have to give to the AG's opinion? And those opinions are simply advisory. You don't have to rely upon those opinions and agree with those opinions. The second is this very peculiar, and this gets into my point about them ignoring the plain language of the statute, right? The plain language of the statute allows for requesters to file a mandamus when public information is being withheld. That is not the same thing as when the Attorney General says public information is being withheld. There are 2 different parts of the statute, and we gave the court a handout. That handout highlights the language that's being ignored, right? What's being ignored is this language refuses to supply public information. If refusing to supply public information equated with the Attorney General saying this is not public information, that would be superfluous language. The Texas Supreme Court, more than exactly a decade ago, in the Callanan versus City of Houston case, said these are not one and the same. These are 2 separate categories, and reading them as one and the same would mean that Attorney General decisions are not reviewable, and that is not the law. And it's staggering that the other side has not only not addressed any of those opinions and the progeny that has resulted after Callahan, but that they're continuing to make this spurious plea to the jurisdiction argument to begin with. And so we have a situation here where horrible shooting, worst shooting in Texas history, no answers being provided at the front end except for the documents I showed you. And then the next step is people request information under our Texas Public Information Act. So our Texas Public Information Act, which has been on the books since 1973, has express public policy in it, talking about the fact that information is presumed open. And it in the preamble says, look, the people in delegating the authority do not give their public servants the right to determine what they should and shouldn't see. Right?
So one day there's a shooting.
Shooting was May 24th, 2023.
One day there's a shooting.
Oh, I'm
The
sorry.
next day, there's a PIA. And give me everything you got. And among the laundry list of exceptions, one of them is a law enforcement. Are you, as the move-in for this information, right, the requester, are you mean to suggest that if the media says, okay, give me a laundry list of stuff, everything happened, identities, reports, everything, and it's the day after an incident, pretty significant one, where even the scene is still active for weeks, if not months, right? Are you suggesting that the government is required to come in and somehow prove with what type of evidence that there's an investigation still going on when that happened the day after? And are you suggesting that the requester, in this case, the media, has no burden whatsoever other than to make the request? No burden to even like no burden that it's in their favor to simply file a request and that the respondent, government entity, is shouldering all of the burden to respond and then show proof why it falls under the exception. You're suggesting that they're supposed to prove some form of evidence, and I'm going to ask you what type of evidence that could reveal itself, to say, yes, there's an ongoing investigation. What type of evidence do you suggest, or there's some precedent to suggest, is necessary for the government to come back and basically prove that there's an ongoing investigation 24 hours after the fact? What does that look like? And that are you suggesting the media has no burden whatsoever as the move-in in a summary judgment setting, in this case, has no burden whatsoever other than to file the motion?
I think we're looking at two different proceedings.
We are, but
So
I'm also looking at the specific circumstances here, because we're not looking at a PIA request that came 6 weeks, 6 months later. It came the day after. So what presumptions do you find High Court, Supreme Court, about how they would view, a request, and who the burdens would be shouldered by? What does this look like? So back to my specific question, what evidence do you feel would have satisfied the burden that shifted to the government to respond to a PIA that basically asked for a laundry list of stuff that let's just say aren't immediately deemed as confidential, and that may or may not fall under the law enforcement exception?
right. So at that moment in time, everything was at the Attorney General's office.
The day after the incident?
That took about 3 months. What
I'm
happened?
talking about the day, on the day that you filed it. What
We
responsibility?
didn't file a lawsuit.
I'm not talking about a lawsuit. You filed a request for information.
Right.
So what, again, does the media or any requester, could they fairly, enjoy under the law of this state, that demands the government to reply to that kind of request under those circumstances?
Right. And under those circumstances, there is, under our Texas Public Information Act, the system in which the governmental body can ask the Attorney General for a ruling.
We get that. And let's assume all of that came back, and they came back and they threw opinions at you. And there's a difference of opinion about what is or what should not be disclosed. You believe that the opinion allows still the disclosure of XYZ. Can we clarify right now, what do you believe, despite the opinions, you are still entitled to what specifically?
Well, we believe that we are entitled to what we have requested
Can you
because
clarify exactly, specifically, what documents have not been, that you believe should have been produced, notwithstanding the opinions?
And so those documents are listed in our summary judgment motion on pages 77 through 80. Okay.
Generally, what they include, what do
They
they?
include things like body camera footage, dash camera footage, policies and procedures to the extent that they existed, hallway video, 911 calls, things like that. But Your Honor, I'm not trying to be obtuse here, but there's two different burdens when you're talking about the day after and things go to the Attorney General. The Attorney General assumes whatever the governmental body says is true. They don't do any fact finding. They very often just rubber stamp, okay, there's an ongoing investigation, move on, you can withhold this information, which is exactly what happened here. Then came the lawsuits, right? The lawsuits weren't filed until the end of the
Let's
summer.
skip to the burdens of the movement, because this is summary judgment motion.
Right.
What's the burden on the movement, and what's the burden under the, by the non-movement?
Under the Texas Public Information Act, in a mandamus setting, the burden, according to the court, Texas Supreme Court, in DPS versus Gilbreth, is that the requester need only show that the governmental body has not produced public information. Then the government.
How do you respond to their position that said, well, we've not really refused it?
And the response to that is, Your Honor, they've not, that in the Callahan decision, the request for the Attorney General decision alone constituted refusal. The Thomas versus Corning case is dispositive on this issue as well. And in the Thomas versus Corning case, what the court said was the burden is on the governmental body to explain how and why disclosure would interfere. Here we do have the benefit of the fact that the shooter is dead and the law enforcement investigation has been completed. Colonel McCraw testified before the Senate Finance Committee in February of 2023 that there is no more ongoing investigation. The district attorney testified that her interest was in receiving a complete and thorough investigation, which she has received. So we don't have an ongoing investigation, which is clear in the record. We have a dead shooter, which is clear in the record. And the only evidence that they've presented to satisfy their burden are 5 grand jury subpoenas for an expired grand jury that they've admitted no longer is convened, and a motion to inspect property of Robb Elementary.
Where is that admission that the grand jury no longer is convened?
The appellate, well, first of all, they just made it in their argument, but also the appellate brief at page 33 references a news article which the court can take judicial notice of. There is a timing issue, of course. The briefing was done here, indictments were issued, then the summary judgment order was granted. So
Would that change? Let's just say, for argument's sake, that in fact the subpoenas showing that a grand jury was still being impaneled, that there were witnesses still being called. What effect, if any, would that have had as, is that sufficient evidence enough to raise at a minimum a fact issue?
no, I don't think it is, Your Honor, because first of all, there's no grand jury exemption in.
As I said, I asked you to presume that in fact that there is or at least there's no evidence to just assume for me, if you would, that the grand subpoenas reflect an ongoing investigation by a grand jury.
Right. I understand, Your Honor. And
Would that change?
no, because the fact of an ongoing investigation is not the same as establishing that disclosure would interfere with an ongoing investigation. Those are two different things. And in fact, some of the changes that were made since Holmes versus Morales. One of them was this would interfere language being added to the 108 exemption.
What would you have expected the government to provide? What kind of evidence have you seen in either the jurisprudence or whatever? What kind of evidence at a minimum would hurdle or at least satisfy their burden to show the exception?
So it depends on the evidence. I mean, what they did nothing, but in cases that they relied upon, things like affidavits were submitted, documents were submitted, expert testimony was submitted. None of these things have happened.
That reflected or evidenced what?
The affidavits reflected the opinions of whomever was in charge, that this would interfere. Here is how it would interfere, things along those lines. The City of Carrollton case versus Paxton is one, for instance, that they rely upon. It's a B2 case. It's not really relevant here. But in that case, it talks very clearly about the fact that vague assertions of risk don't carry the day. You have to have specificity in these affidavits. The Paxton versus Escamilla case, which they rely upon, again, highly different circumstance, but in that circumstance, they had 2 affidavits in camera review and open deferred adjudication issues still in play. So very clear and defined examples as to why and how disclosure would interfere. None of that happened in this case. None of it happened. And so we have a situation where these governmental bodies are ignoring the language under the sovereign immunity waiver. They're ignoring the requirement that they have to establish that the information would interfere, and they're ignoring their burden under 166AC that they actually have to provide some information about these other exemptions where they, once again, they haven't even identified the documents at issue. And so when you look at the second page of our handout, it goes through what I'm talking about there and the fact that, for instance, in the deliberative process exemption, they never identified the documents at issue, let alone explained how they were pre-decisional, deliberative, or pertain to some formation of policy.
So you're saying that's part of their burden at trial? If you're going to pull on an exemption, you're going to have to identify how this exemption, there's a burden on them, it's not on you?
Correct. Thomas versus Cornyn says that. DPS versus Abbott says that. DPS versus Cox says that. Vague assertions are not enough. They didn't even give us vague assertions. They didn't even identify the documents. They did nothing here to sustain their burden. So here we've got a situation where it's been 1,000 days since this tragic event, more than 1,000, 1,036 to be exact. And despite the fact that the shooter is dead and there is no ongoing investigation, Colonel McCraw has indicated that, DA Mitchell has indicated that. The investigation's closed, but the public is no closer to having answers to what happened that day. And that is because the people who responded that day have all refused to produce the information. And I want to be really clear to this court. This is not about casting blame. It's about the public's right to know and to be a part of the discussion about how tragedies like this can't happen in the future. But that doesn't happen in a vacuum. And so we have uniquely in this record, we actually have the legislative history from the people who sponsored 108. And the people who sponsored 108, the lawmakers who sponsored it, said this exemption should not be used to cloak in secrecy the actions of law enforcement. And even went so far as to say any court that is considering the intent and meaning should side with those who want to know what law enforcement is doing.
Do you feel like we need to have to analyze the exceptions one by one to determine whether they apply or not? Go one by one. And secondly, what determinations are we permitted to make as a matter of law? And which ones should we review and assess to determine, even if there's a scintilla of evidence to raise a fact issue?
So I think you can very blanketly say they didn't meet their burden on the other exemptions because they produced nothing to support the other exemptions. I think as a matter of law, what you can determine, and the court the precedent sets this out very clearly, is that the documents were subject to the Public Information Act and that they didn't meet the burden of establishing that a narrow exemption applied. And I think that would be consistent with, that outcome would be consistent with the policy that's put forward in the Texas Public Information and the record that is presented before this court. We request that you affirm summary judgment.
5 and 5, counsel.
May it please the court. Council has referred many times to the Callanan case. The Callanan case simply says that the requester for information can file a lawsuit and does not have to wait for an attorney general's opinion. That's what that case says. Where I think we're being a little bit misconstrued here is, what is public information? Public information is when the governmental entity does not release public information. But it's not public information if the attorney general states that it is subject to the exemption. At that point, the governmental entity has met its burden of showing governmental immunity. And that's what we contend in this case. We met our burden. We had an attorney general's opinion. That opinion said the document, what we're talking about, body-worn cameras and the documents are exempt under 108. And that met our burden. When they filed a motion for summary judgment, we filed the subpoenas from the grand jury. And the filing of the subpoenas from the grand jury not only show an ongoing criminal investigation by the district attorney, but also a prosecutorial action by the district attorney, and that meets the standard.
Yes,
When
sir,
you-
I have a question.
please
for
go
you. Oh,
ahead.
Go ahead.
You sure?
Go ahead.
You presented a bunch of stuff before the Open Records Division. You know, you provided representative samples of the requested documents. And I'm curious why none of that evidence in any form was provided before the trial court here, with the exception of these 2 items that were pointed out by counsel.
Because we felt we met our
Why was
burden.
there not more of an effort to provide summary judgment evidence below?
We didn't feel it would be appropriate to actually have body-worn camera footage, which the district attorney is requesting that we not produce, put in our trial in the state court case. We didn't feel that was, one, appropriate, and we felt, 2, that we met our burden by showing, look at the grand jury's meeting. It's ongoing investigation. That's our burden.
Well, before I reverse a trial court, I want to know what they were able to do. What did the trial judge have before him or her? In this case, it was a him. And we know what was before the trial court because we have it in the record. And in the record, as has been pointed out by that police counsel, by the media, is that there was no real evidence marshaled in before the trial court when it determined the summary judgment motion.
That's correct.
So I'm curious, because that marshaling of evidence was done before the Open Records Division, not a trier of fact, but, you know, not a courtroom, but just a division, state agency of the, I don't even know if it's a state agency, it's a division of the executive branch. I'm just curious why that same evidence wasn't proffered before the trial court for it to consider as a fact finder when it determined the motion for summary judgment.
Because we feel we met our burden by showing that the grand jury is still meeting, our employees and the sheriff are being questioned by the grand jury. That shows that it's ongoing, period. And the attorney general opinion said we didn't have to produce them.
And how do you respond to counsel's representation that the grand jury that it purports to have been submitted for was no longer impaneled?
That's not accurate as far as I know. I think she's quoting from a newspaper. As far as I know, the grand jury is still impaneled. The district attorney's here in this courtroom. I don't know that that's an accurate statement.
So
The
I have
other-
a question for you.
Yes.
There's been some discussion about the case out of the 15th Court of Appeals. And it sounds like there's a disparity in what DPS presented and what you guys presented. Everything from, I heard a thumb drive to affidavits and some real evidence. And I assume before that point that the procedural history was, it mirrored your procedural history as far as going to the AG's office and getting an opinion. Can you see how it was a little bit easier for that court to at least look and recognize it was all this evidence presented at summary judgment to the trial court? And we have really nothing but, I think, 5 subpoenas to consider. I mean, that's a real difference, right?
The difference is, one, the 15th Court of Appeals, they have a lot of information that which they haven't looked at as of yet because it's so
It is
voluminous.
very voluminous, yes,
But
that's correct.
We only had a burden to show that there's an ongoing criminal investigation. That was our only burden. Once we did that, governmental immunity attached. And their motion for summary judgment did not defeat governmental immunity. And that's all we needed to show with regard to Holmes versus Morales. I know that it has changed. The Attorney General as late as 2024 still interprets in the current law that is all that is required to show that an ongoing criminal investigation, period. And I think we've met our burden.
You can have a couple extra minutes.
The other cases that I would like to talk about is my opposing counsel talked in their brief, Simons versus Kuzmic. That is the difference there is the chief failed a timely request an AG opinion. So there's a lot of different steps. If you fail to do that, then there's the presumption that it is public information, and then there's a different burden. Our scenario is there was an AG opinion issued. We timely submitted it. There was an opinion, and we supplied the information pursuant to that opinion. Therefore, we believe we've met our burden, and the governmental immunity has not been waived. And that is the basis of our what was initially an interlocutory appeal, but now is an appeal of a final order. And I believe we've briefed that, and I think all counsel perhaps agrees that it's a final judgment.
I do have a question, Mr. Frigerio.
Yes.
Are you saying that the people of Uvalde have to wait until the statute of limitations expires on endangering a child before they're going to get the complete information that the Texas Public Information Act guarantees them that they can get?
I think they need to wait until the criminal process has gone its course, not for a statute of limitations to have been expired. Because on a lot of these, we're talking about children, and that statute of limitations is not going to expire.
So you're saying there's other crimes that are being investigated other than endangering a child?
That's what I don't know, Your Honor, because I'm not the state of Texas, but I know I keep receiving inquiries from the DA's office. And that's why we're caught in a Hopkins choice, because we don't want to cooperate. None of our people have ever taken the Fifth Amendment. But at the same time, there's still that potential possibility of criminal jeopardy. And that's something that's very real.
For your officers?
Potentially.
And so are you saying that maybe if this information is released to the public before the grand jury can hear the evidence, that maybe the witnesses won't want to cooperate?
I don't know, Your Honor. I just know, Judge, that we have been requested to withhold the information, and we've tried to do our best to cooperate with the district attorney, although being a separate governmental entity. And we're doing our best to try to do that.
Thank you, counsel.
Thank you.
Your Honors, I just want to respond very briefly. We're not conflating the two categories under 552.321. Never have been. We're not saying that AG opinions are unreviewable. We're not saying that they're binding authority. We're saying that they're persuasive authority. And in this case, they have been submitted as evidence that those exclusions apply. As it stands right now, the trial court finding is that we had multiple requests for decisions addressing several different exceptions from the PIA that were submitted by two separate government entities. And the agency that the legislature has charged with interpreting the PIA just got it wrong over and over again. And I would submit to you all that that's not the proper resolution of this case, that there are jurisdictional and fact questions. And for that, we ask that you reverse and remand to the trial court. Thank you for your time.
Well, this case will be submitted and an opinion issued in course. Court is adjourned. All right. Thank you.